Welcome back to Legalese 123, where we are covering cases across America. Welcome back to Legalese 123. I'm your host, Misty K. How is everybody doing today? Today is Tuesday, November 25th. Now, it's technically Taco Tuesday. Do you participate in that? Are you going to have Taco Tuesday today? Do you even cook today? Since Thanksgiving is on Thursday, do you not cook until Thursday, the big day? Maybe you're traveling and therefore you definitely aren't cooking. You're going to be eating out. But whatever the case may be, it's Taco Tuesday. So, what do we got going on today? Well, today we're going to revisit a couple of things going on in the Aaron Spencer case. Why? Because that thing is heating up. Remember, all motions and responses are supposed to be due by December 3rd. I just saw a filing from the defense saying they can't make that deadline. Why? And we'll see in just a moment. There's also other things going on. Both parties, both the prosecution and the defense, are throwing things in the mix. So let's just get into it. But before we do, we're just going to do a very small recap. Aaron Spencer versus Arkansas. What are we talking about? Aaron Spencer is charged with killing. Aaron Spencer, who is 37, I guess he's 38 now, is charged with a second-degree murder and firearm enhancement for shooting the death of Michael Fossler, who is 67. Fossler has been charged with sexual offenses against Spencer's 13-year-old daughter. He was out on bond for these sexual offenses, and something happened. So on October 8th, Spencer woke up to hear that his dog was barking. I guess his daughter turned 14 at this time. So his 14-year-old daughter, he went to her bedroom. She was found missing. She wasn't in her bed. He told his wife to call 911. He quickly got out into his car and went to go look for Fossler. He happened upon Fossler, and guess what? Fossler had his daughter. At this moment in time, he then tried to get Fossler to stop by blinking his lights and trying to get him to pull over, but Fossler wouldn't do it. So he did what's called, I guess you could say, a pit maneuver, where he tapped the back of Fossler's truck and it did like a spin and landed into the ditch. According to Aaron Spencer, allegedly, he asked Fossler to get out of his truck. Fossler did not immediately respond. He asked for his daughter to get out of the truck, and it looked as though Fossler was holding his daughter and not allowing her to exit the vehicle. Eventually, Fossler came out of the car. Spencer alleges that Fossler had something in his hand. He didn't know what it was. He had told Fossler to get on the ground, and Fossler told him, F you. Spencer then went ahead and shot him several times and then got his daughter out of the car and called 911. Later on, it is learned that Fossler, who was charged with assaulting his daughter, he has 43 counts of different various crimes against him, and Spencer's daughter is the victim in that case. He was ordered to stay away from her, but not specifically her. There was just a stay away protection order. Later on, it was found out from Aaron Spencer that Fossler had contacted his daughter on 3 different occasions. It's not quite clear whether or not she did go see him, but on this night in question, he lured her outside. Fossler lured Spencer's 14-year-old daughter outside at midnight, took her to his home. He sexually assaulted her again, and that is when Aaron Spencer came upon him. Aaron Spencer did not know that they were returning from that sexual encounter. The police arrived at the scene and they took Spencer into custody immediately and charged him. So apparently it's been known that Fossler had been grooming and assaulting Spencer's daughter many, many, many times. He was released on a very low bond. He had a $50,000 bond, got out, posting $5,000. And this happened in July 2024. The road incident when Aaron confronted Fossler happened in October of 2024. So here we are now. This is set to go to trial. Is Aaron Spencer justified in his actions? So, there was a continuance given to both parties. All documentation is due by the 13th of December, or the 3rd of December. And here we are. So there is a pre-trial hearing set for December 17th at 9 a.m. Trial is set for the 26th through the 30th. So we have a couple of motions that the state has filed, and we're going to go through those as we speak. So let's see which one we have here. One moment, please. By the way, I don't know if anybody saw, but Netflix has a new series about Selena. If you don't know who Selena is a Tejano. Well, she was a Tejano. She was a Tejano musical prodigy, I would say. She sung very, very well. And anyways, if you haven't seen it, go check it out. It's very, very good. All right, so here we are. We are talking about they've got many motions that have been filed. So let's look at this one really quickly. So this is reply in support of defendant's motion in limine to exclude evidence. So remember, we talk about motions. What's a motion? Before a trial happens, the defense and the prosecution have to explain what the defense strategy is going to be. What are they going to argue? They also have to say what kind of evidence might be coming in, what experts are going to testify. And obviously, whatever evidence is going to come in, the prosecution has to turn it over to the defense. So the defense has the ability to look over the evidence to decide whether or not they think it's eligible to come in, and also how they can explain it away. Remember, it's the job of the defense to poke holes in the prosecution's theory of the crime, and it's the prosecution's job to convict beyond a reasonable doubt. So it's a game, right? And so these motions go back and forth saying what each one's going to do. And then they go back and forth saying, no way, you can't do that. And so then the judge is the decider, and the judge looks at the arguments that both of them have made. And the judge then decides what evidence is and isn't going to come in. And so this is what we're preparing for. That is what the pre-trial conference is going to be. The judge will look at all of the motions and decide what's going to come in and what isn't going to come in, who can testify, who can't testify, etc. And then the trial happens. All right, so the defendant, Aaron Spencer, by and through his attorney, so this is the defense motion, submits his reply to support of defendant's motion in limine to exclude evidence along with accompanying brief in support. Spencer is charged with second-degree murder under the Arkansas Code, and he has asserted complete justification defense. So that is what he is affirming. He's going to go with that he was justified in his actions. Once raised, justification is considered an element of the offense, and the state must disprove it beyond a reasonable doubt. Thus, the determinative question for trial is whether Spencer reasonably believed that Fossler was committing or about to commit a felony involving force or violence, was using or about to use unlawful deadly force, and was imminently endangering the child, and whether Spencer's actions were necessary as an emergency measure to avoid imminent injury. Remember, Spencer did not know that Fossler had picked up his daughter at midnight and had taken her and had already assaulted her, and that he was returning home with her, because this incident occurred around 1:15 a.m. The state's response presents a distorted and incompletely factual account while omitting the chain of events that actually culminated in Fossler's death, namely Fossler's repeated sexual abuse of a minor, his release of bond for 43 felony sexual offenses, and his ongoing manipulation of the child until the night he took her from her home. because there's a big question here, right? The prosecution said that she consensually is having this relationship with this 67-year-old man. Remember, he is 67. She, when this started, was 13. Do you think that that is a consensual sexual relationship? All right. Spencer and his wife cooperated fully with law enforcement when the abuse first was discovered. They allowed interviews, provided information, consented to searches, and delivered their daughter for a forensic interview. Then, 4 days later, Fossler was arrested and charged with the 43 counts. The state's attempt to recast Spencer as someone seeking to take the law into his own hands, quote unquote, directly conflicts with the extensive record of cooperation. What occurred on October 8th occurred only because Spencer discovered his daughter was missing, saw her inside Fossler's truck, and observed Fossler fleeing with her and refusing to surrender her. The state also attempts to rely on statements Spencer made in July of 2024, months before the incident, as if they shed light on his conduct on October 8th. They do not. So again, the statements that he made when he first discovered that these actions were taking place against his daughter, he then law enforcement came over, he cooperated fully. He did at the time talk about, taking the law into his own hands. Is that a precursor or a prelude for him saying, "Okay, here I am, and, months later, I'm taking the law into my own hands." Again, this is for the judge to decide, right? Those comments were emotional reactions upon learning that his daughter had been completely raped. Can't say that word on YouTube. They were not accompanied by threats or violence, and Spencer immediately calmed and cooperated with officers. Prior statements are prior statements are admissible only to prove motive, intent, plan, preparation, or absence of mistake. Here, the issue is not whether Spencer intended to kill Fossler or planned to do so. The issue is whether Spencer acted under a reasonable belief or imminent danger. Do you think he acted under reasonable belief or imminent danger? Nothing in the July statements tends to prove or disprove any of the required elements of the state's case or justification defenses. The state identifies no 404B permissible purpose, and the statements therefore are inadmissible. Even if the July statements had marginal relevance, which they do not, they must be excluded. Their probative value is negligible because the statements do not concern Fossler's conduct on October 8th, do not address the threat he posed that morning, and do not make Spencer's precipitation of danger more or less likely. By contrast, the danger of unfair prejudice, confusion of the issues, and misleading the jury is substantial. Allowing jurors to hear months old emotional reactions risk transforming the trial into a referendum of Spencer's initial anger rather than the circumstances of the assault, flight, and threats that occurred on the morning of the incident. Rule 403 requires exclusion when evidence invites emotional judgment or diverts the jury from the central questions at trial, which is precisely what would occur here. Now remember, this is the defense's motion. They are arguing that these statements should not be let in. The state obviously has filed motions that say we want it to be let in. And it's the judge's decision to review this information, review the laws, review case law to find out whether or not she agrees with the state or she agrees with the defense. The state's argument also rests on the untunable premise that Spencer somehow had good reason to believe that his daughter was not in danger, simply because she may have left her house voluntarily. Right, the state is alleging, well, she left voluntarily, so, there isn't any danger, right? This misunderstands the dynamics of a child sexual abuse and ignores the legal reality that a 14-year-old victim cannot consent to a sexual act with a 67-year-old abuser facing life sentences for crimes against her. Again, I wholeheartedly agree with this statement. Regardless if the 14-year-old girl went with him willingly, is that acceptable, right? Why did she go with him willingly? what has been transpiring in these several months, plus however long this has been going on. We don't know. We think it started around when she was 13. Um, uh, but again, they say that he groomed her, etc. Does a 14-year-old girl have the right to consent to a 67-year-old man? Whether she was groomed or forcibly taken is irrelevant. Either scenario created a reasonable and imminent threat of harm. No Arkansas statute requires a parent to call 911 instead of acting to stop an abuser fleeing with a minor victim. And Spencer knew his wife was already on the phone with emergency services. The only relevant inquiry under these rules is whether Spencer reasonably believed force was necessary to prevent imminent injury, and the state's own probable cause affidavit confirms that he did. Because the July statements do not bear on the operative legal questions and would serve only to prejudice and mislead, they are inadmissible under the Rule of Evidence 404B, must be excluded under Rule of Evidence 403. The jury must decide the case based on the events of October 8th, Fossler's actions, his continued control of a minor victim, his refusal to release her, his aggressive approach towards Spencer, and the imminent danger those circumstances created. Allowing this state to distract from those facts with the months-old emotional comments would improperly taint the jury and distort the issues they are charged with deciding, sorry. So, again, we kind of talked about this before. If statements that come in are against what is happening, right? If like if they're defamatory and paint you as a bad person or bad character, those are inadmissible. All right, so let's go and get the next one. Do, 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 do. See, I'm getting better at this. All right. Let's see. Can I do it more and more? Or are we going to be off the page a little? Or off the page a little? Okay. Well, I'm trying to make it big for you, but I'm still trying to figure out how that will work. Let's see. Let's go like that. Oh, right. I don't know how to get rid of that. Okay, here we are. So, a brief in support of the motion to exclude evidence concerning cell phone tower data. Thought this was really, really interesting. So, the defendant, Aaron Spencer, by and through his attorneys. So, this is a defense motion. Brief in support of motion to exclude evidence concerning cell phone tower data. The discovery file disclosed by the state contains allegations that the state can use cell phone location data to decipher the location of a phone, and therefore its owner, at a given time. Specifically, the state has disclosed a 12-page PowerPoint presentation with 3 slides showing the purported location of Spencer's phone at various times near the time of the charged act. While the evidence at issue essentially shows what is already known about Spencer's case, it still may be excluded under Rules 401, 403, 702, and 803. Any marginal probative value the evidence has, which Spencer does not concede, is substantially outweighed by the very real dangers confusing the issues, confusing and misleading the jury, and unfair prejudice. Okay, so what is happening is that the state alleges that as Spencer was driving to go find Fossler, they said that he could have called 911 at any point in time, and therefore this wouldn't have escalated, and therefore this incident may not have occurred. Spencer states that he was driving and he had received a couple of text messages. He says he didn't read them. The state says he read them, and that I think that there was a phone call that was alleged to have come through, and I think the defense is saying it went to voicemail, and they're saying that he could have called 911. He said he was driving and was unable to manipulate his phone. So the prosecution is coming through with this evidence stating where was his cell phone, and the defense is saying that their analysis is wrong and can't come in. Spencer objects to the introduction of any testimony or evidence claiming to be able to discern the location of the phone at various times because it does not meet the threshold for scientific testimony, including the above mentioned PowerPoint presentations of any testimony. The state disclosed this information midday on Thursday, November 20th, 25, the second to the last business day before the motions deadline, Monday, November 24th. The expert CV was provided today, November 24th. Defense counsels are still working on reviewing and analyzing the report and related data. Remember, all of this stuff is due this week, and responses and stuff are due by December 3rd. The defense just got this stuff dumped on them, which is normally what happens. And so they are trying to quickly go through. Such evidence does not satisfy requirements set out in Daubert. It is otherwise speculative, unfairly prejudicial, and lacking in proper foundation. Daubert, what's Daubert? Daubert requires that any scientific testimony or evidence reliable that focus on Daubert was a case that they're citing, and this is what their interpretation is that any scientific testimony or evidence must be examined on the principles of and methodology, not the conclusions. The mere fact that there is a certification does not mean that a particular protocol satisfies Daubert. For example, law enforcement officers may be certified to do a polygraph examinations. However, the results of any such polygraph examination are inadmissible in all courts in the state. The proponent of the evidence bears the burden of proving by a preponderance of the evidence that the conditions of inadmissibility exist. That burden will be difficult to meet here because the state's proposed evidence regarding alleged cell phone location is derived from data supplied by AT&T, which expressly warns that the data is unreliable. The records state, the results provided are AT&T's best estimate of the location of the devices with the specific search. AT&T makes no guarantee as to the precise accuracy or volume of records. Please exercise caution in using these records for investigative purposes, as location data is sourced from various databases, which may cause location results to be less than exact. Exactly. So when you're driving past a cell phone tower, your phone obviously will ping off of that. It cannot tell you that, if you're inside of a building, it can't tell you exactly what building you're in, what room you're in, what floor you're on, what room you're in. Are you in the bathroom? Are you in the kitchen? It can't pinpoint to that exact. It can give a radius, right? Usually I think anywhere between 100 to 1,000 yards, it can give a radius. And in some cases, that might be too large of an area. Now, it can put you in the area, and that sometimes is good evidence to come in. But if you're trying to exactly pinpoint exactly where a person is, it can't do that. And remember, we part of these discussions is about technology. What are the technological advances that are going to put defendants behind bars? What technological advances are going to help keep them out of bars, right? Help keep them out of jail. And this is what we're learning as we go along. So thanks for joining me today. Hey, by the way, have you liked or subscribed my channel? I've got 43 subscribers right now. I need to get to 50 by the end of the month. So hit that like button and subscribe, okay? The suggestions that such data can pinpoint a device-specific location is unsupported, lacks the reliability required for admissibility, and amounts to nothing more than junk science. Oh, she's good, right? Now remember, in their motions, they can write whatever they want, right? Some motions are really good and make for a really, really good read. Other motions are boring. There is no accepted methodology that would support the opinion suggested by the state. Daubert set forth for non-exclusive factors in determining reliability, whether the technique employed or relied upon the expert has been tested. Oh, we'll skip that. Courts have regularly required this information to be presented in court to permit the sitting judge to make a determination while performing the gatekeeping function. All right, let's continue on. So again, what I said, they have their motions. They use supporting evidence from prior case laws that cases that have gone to court, and then the court says, okay, we rule in this person's favor based on XYZ. Then they use this to make their argument. I'm not a lawyer, so some of this information is a little bit beyond me, but we can get the gist of the papers. Even the PowerPoint presentations itself makes clear that the information contained within is unreliable. The presentation notes that the cell phone's call record and list of cell site locations are quote unquote used to illustrate an approximate location of the target cell phone for the network interactions. See PowerPoint 2 slide. We'll see that in just a minute. Further, the presentation notes that the analysis is based on and relies entirely on cell site location provided by the service providers and/or National Domestic Communications Assistance Center. Further, the presentation notes that typical cell phone towers are configured with each sector covering approximately 120 degrees. The presentation notes that the cell phone at issue will generally be located within a shaded arc, but might be located closer to the tower than depicted arc distance. Remember, I told you it's within a certain radius. And if you're saying, hey, this person's cell phone was in this radius, therefore he committed the crime, that's good. But if you're saying if he is on First Street in front of XYZ's person's house, they don't have the technology yet to pinpoint that. Now your phone might. Anyways, what is known about using cell site analysis to postulate cell phone location is that there is no way to pinpoint a cell phone's precise location from historic CSLI, and there are no known validation or error rates for the methodologies used to collect and analyze this data. Rather, the data being analyzed comes from unvalidated records of cellular network operations and unvalidated information about the cell tower locations collected by phone companies for network billing purposes. Even a cursory review that council has been able to do between receiving the PowerPoint from the state Thursday and Monday, when the motion is due, the PowerPoint appears to contain erroneous information about the process and its functioning. You see, the prosecution probably wants to bring this in and say, this is what we conclude. And if the information that they're bringing in to show the jury is wrong, you can't do that. You can't bring in false information and be like, well, this is what they said. So again, the judger is the finder of fact, and she needs to assess whether or not this information is accurate and who's going to report that it is accurate. And again, this is where the battle of the experts come in, right? The judge might look at this and say, well, they're not exactly saying this, they're saying that. And then this is where the oral arguments come in between the two parties. If she's not completely wholeheartedly convinced, then she just says, all right, well, you bring in your expert and you bring in your experts, and what expert's going to win? The produced report paints a misleading and inaccurate picture as to precise locations and oversimplifies what is complex assessment. Most significantly, the images depicted in the report are highly misleading. For example, it suggests that the signal from the cell phone tower propagates strictly at a 120-degree wedge. However, cellular antenna radio frequency coverage consists of main lobes, side lobes, rear lobes, as illustrated below using radio planner. Sorry, my cell phone's going off. On the right is the FBI's training manual. In real world, the defendant would be as far as Ferndale, which is the opposite direction from where the FBI manual relying on a 100-degree wedge is pointing. Okay, so they're disputing where he was actually located, right? So we're going to, this is 12 pages. We're going to kind of zoom through here. What the data does not accurately show about Spencer's movements in the area is already known, so adding this testimony that does not contradict the other information but presents speculative possibilities inserts confusion into the trial, may mislead the jury and certainly creates prejudice. Sure, if they say he's somewhere else and then he's somewhere else, that could definitely confuse things. So, Spencer requests that this court make specific factual findings on the Daubert factors. The court should not permit any additional supplements of data and should instead exclude this expert testimony at trial for this reason and all the reasons herein and accompanied to the brief of support. The court should conduct a hearing at which it considers evidence relevant to Daubert. Again, they want to have, so there are several different things that they want to have. They want to have a Daubert hearing, which means that the experts come in and testify. And that means it's not in front of a jury. It's just the judge and the defense and prosecution. And they get to ask him everything, anything and everything under the sun. And that's where they go through what they're testifying in this case and what their expert opinion is going to be. And that way each side knows what this person is going to present in court. That's called a Daubert hearing. The other one the prosecution would like is called an evidentiary hearing. It's kind of one and the same sort of thing. One is what evidence is coming in and why. So we'll see. The state's witness certainly should not be permitted to show the jury a diagram or present any testimony that purport to show definitively where a person's cell phone was located in a particular time. They should find that the evidence is not relevant. The court may exclude any evidence purporting to pinpoint the location of Spencer's phone on the morning of October 8th, including the PowerPoint presentations at issue. So this is the report, which I find so exciting. Looks like the FBI did this. That is one of their states, one of the witnesses. And typically, they don't exclude the FBI. So it's the FBI CAST team. They talk about what the sectors are, the advanced timing plan. Uh-oh, why is this not going down? Oh, maybe that might be it. Yep, that's it. Let's hang on, I gotta move this up a little bit. Round trip network, device generally located. That's just sort of like their general how we do things. So that'll be interesting whether or not this information put in and exactly what is the prosecution going to do with this information. All right, let's move on to this next one here. Share the screen. Do you do that too? Do you like sing as you're going along and doing things? Do you every once in a while you'll talk about something and then it's like you're like da 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 and then you sing lines in your head. I could sing lines all day long. All right, let's go. All right. So, this is a brief in support of the motion for individual or small group sequester voir dire. So, this is interesting. Spencer requests that the court permit counsel to conduct a voir dire of prospective jurors individually. Okay, so voir dire is where they question the jurors about whether or not they are going to be set as a juror on this trial. And so the defense is asking to, each court has their own procedures. And so they're asking for this specific procedure for collecting jurors. So, they want to do it individually or in small groups outside the presence of the remaining panel. So, they want people to come in and other people have to be outside so they don't hear the rest of the people. They don't want it to be a big, sometimes they do it in a big, large group and they say, has anybody heard anything about this case? And then like they raise their hand and then they just like, you, gone, 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 gone. They want to do it individually and have them come up. You have a questionnaire that you fill out. They want to have them come up and perhaps individually or in small groups so that, again, it doesn't taint the other jurors. I think that's very smart. That the jurors who have been questioned be sequestered until the jury selection is complete and the prospective jurors be admonished not to discuss the case with each other. Spencer is charged with second-degree murder with a firearm enhancement. The case involves killing Michael Fossler, who sexually abused Spencer's daughter and who, despite facing 40 pending felonies related to that abuse, picked her up on the sorry. These filings, they're just getting better and better. Their writing is fabulous. Again, most people don't read these before they go into court. I'm just you and me, we're weird law nerds and we want to hear all of these things that happen beforehand. I don't know if I could ever be on a jury because if I knew the information prior to this, they'd be like, "You're excluded. You already know what's going on. You're supposed to come in with an open mind and not know the facts of the case." Okay, so this is really good. And I'm not this is nothing to laugh at, but just their snarkiness in the writings are just delightful. The case involves the killing of Michael Fossler, who sexually abused Spencer's daughter, who, despite facing 40 pending felonies related to that abuse, picked her up in the dark of night to continue victimizing her until Spencer intervened. Spencer has raised justification defenses, including that he reasonably believed Fossler posed an imminent risk of harm to Spencer's daughter and to Spencer himself, and that force was used unnecessary to avoid harm. Well, hold, please. Welcome back to Legalese 123, where we are covering cases across America. Whoopsies. Sorry about that. Sometimes that happens. Had to pause for just a second. Again, this is a new thing for me, so all right, let's continue. Because these issues are deeply sensitive and highly charged, jurors may either influence one another's views during group or voir dire or hesitate to share their true feelings in front of dozens of community members. Either outcome risks distorting the voir dire process and undermining the court's ability to seat an impartial jury. The case has also received public attention due to its subject matter and because of prior proceedings, included review by the Arkansas Supreme Court. In addition, several individuals connected to events live in Lonoke County and may be known to potential jurors. Members of Spencer's wife's family and Fossler's family have deep roots in the community. Both Spencer and a key witness, Sheriff John Staley, are candidates for public office, adding further publicity. These circumstances increase the likelihood that prospective jurors have been exposed to extrajudicial information or hold strong opinions that could influence others if expressed in a group setting. A more searching inquiry is possible during individual or small group voir dire. Complete and candid answers are far more likely in that setting than a large group questioning. Individual questioning is essential to identifying bias or preconceived opinions, free from the risk that jurors adopt answers they have heard others given. Conform their responses to group expectations, right? They can influence each other, right? Or they can, when you're in a group, you sometimes speak up because you know something or it's important to you. Sometimes you won't speak up because you don't want others to know what your business is, right? The prospective jurors explain what they have heard about the case. They often repeat details that may be inaccurate, inflammatory, or inadmissible. Doing so in front of the other prospective jurors risks training their entire panel. It is crucial to determine what prospective jurors know about the case, what opinions they hold, and whether they can set aside that information, decide the case based solely on the evidence and law. Conducting that inquiry in the presence of the full veneer, however, risks contaminating the panel and jeopardizing Spencer's right to a fair trial. Counsel cannot meaningfully explore these issues without individual voir dire. The failure to do so would deprive Spencer of effective assistance of counsel and his federal and state constitutional rights due to process of impartial jury. When they cite some case law, For these reasons, Spencer asks the court to adopt the procedures of the voir dire that allow for full and complete voir dire of jurors to be provided reasonable assurance that prejudices will be discovered. Individual or small groups sequestered voir dire is the most reasonable method by which this can be accomplished without simultaneously tainting all other potential jurors. In this case, individualized or small group sequestration voir dire is necessary to safeguard Spencer's rights. Because remember, it is all about Spencer's rights, right? He's the right of the accused. He has the right to a fair trial. He is innocent until proven guilty. So anything you can do to protect his rights, the judge usually grants that. And if they don't, then this can be brought up on appeal if he is convicted, and that could be one of the reasons why he needs to get a new trial. So, all right, I'm going to pause here for just a quick second. So I'm going to see if I can find something else. So hold, please. Okay, and we're back. So I found this motion. It is the state's motion, so it is the prosecution. They want to exclude background of facts not known to Spencer at the time of his offense pursuant to Arkansas Rule of Evidence 401 and 403. So remember, he made statements that he didn't know certain things were going to happen. And so let's see what the state has to say in reference to that. So in Spencer's response to state's motion for gag order, the defense alludes to information suggesting that Fossler was known by others, both in Arkansas and other states, as being sexually depraved. We might not talk. Fossler came from Indiana, and he lived in Indiana for a very long time and then moved to Arkansas. And another person has come out and stated that he abused her. So these are facts that we're still trying to figure out what's true and what isn't. Information that was unknown to Spencer at the time of the shooting is irrelevant. In order to ensure fairness and avoid the risk of confusing the jury, the state respectfully removes to exclude any evidence of Fossler's character that was known to Spencer at the time of the shooting. Oh, boy. Oh, man. So they want, oh boy, oh boy, oh boy, oh boy, oh boy. They want to exclude that he's been a sexual predator in other states and possibly within the own area there in Arkansas. Oh boy. Oh man. All right, well, this is going to get good. Any evidence of Fossler's character unknown to Spencer is inadmissible. Evidence of a victim's alleged violent character is not admissible if the defendant was not aware of it at the time of the killing. Facts about Fossler that were unknown to Spencer at the moment he pulled the trigger could not have influenced his perception, his state of mind, or the objective circumstances of the encounter. Such evidence is therefore irrelevant and carries a substantial danger of confusing the issues, inviting speculation, and diverting the jury into collateral mini-trials. It is therefore inadmissible. Oh boy. Wow. Wowzers. Oh, interesting. So wow, how is that going to play out? That's really interesting. All right, let's see if there's, I wonder what the response to what the defense is going to ask for. All right, so what am I looking at? I am looking at, I'm going to share this here in just a second. I am looking at the docket. What's a docket? So each case has what the charges are. Oh, well, hello, let's share to the stage. So each state has a list of what the case number is, the filing date, where it's at, what the status of the case is. And then this is just sort of like who's participating. You got Judge Barbara Elmore, the state of Arkansas, the prosecuting attorney, the defendant, the defendant's attorneys. Now, wait a second. We just read that thing. And this is what he's charged with: second-degree murder. Sorry about that. Hope I didn't burst your ears. Second-degree murder, and remember, he's got that firearm enhancement. All right, and so this is what's called the docket, and each one of these is filings and notices that are being put on there, and then these are the motions. So we're all the way down here because everybody and the mother was filing something. Now, that one that we just read was listed by the state, and they said that this person was a defense lawyer. Defendant, respondent, attorney. But it says state's brief, state's thing. So let's see. We just read this one. State's reference to alleged glass smoking. I am thinking that these are the states, because why is she listed under the states versus why is she listed under the defense? Doesn't make any sense. Because these are the defense attorneys right here. All right, so that is very, very, very interesting. They don't want like his prior bad acts to come in. Wow. So there are going to be a lot more motions coming back and forth. Again, probably the court ends today. So far, nothing's been filed today. Today being the 25th, so nothing's been filed today thus far. I think Arkansas is a little bit behind us. So as you can see, some of these had come in late last night at like 5:54 p.m. So there might be some more filings today. So if there are, I'll see if I can brief you on those. But like I said, the defense has just gotten a whole bunch of stuff dumped on them, and that happens in trials. And they're asking to extend the deadline through December 3rd. So will the trial actually happen when it's going to happen? They might have to push it back. Maybe they're going to push the evidentiary hearing back, or the pretrial, sorry, not the evidentiary, the pretrial hearing. That's where she goes through these motions and says yay or nay, what have you. If they want to do a Daubert hearing or they want to do an evidentiary hearing, that might push things back as well. So you just never know. So that's all we have going on today in the Aaron Spencer case. Again, it's heating up and we're getting a little bit more information every day. So definitely like and subscribe, put a mark, and make a comment. Let me know how you think this case is going to go. What are your thoughts and opinions? Is he justified? Is he not justified? And are there any cases that you're interested you'd like for me to cover? Have a good night and a good evening. And if I don't come back before Thanksgiving, have a happy Turkey Day. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.